Good morning, everyone, and welcome to today's edition of the Maricopa County Board of Adjustment. Rosalie, would you please take roll call?
Chairman Loper,
Present.
Member Cardin,
Present.
Member Ward,
Present.
Vice Chairperson,
Present.
Member Clapp.
Here.
Chairman, we have a quorum.
Thank you very much. I'll proceed to the announcements. This meeting has been noticed in accordance with the open meeting law of ARS 38-431. Agendas are available within 24 hours of each meeting in the Maricopa County Planning and Development Office and are also available on the Planning and Development website 1 week prior to the hearing at www.maricopa.gov/planning. With respect to the hearing process, cases will be considered in the order they appear on the agenda unless otherwise agreed to by the board, and there are no changes to the agenda. For each case, the applicant will be given a set amount of time to present their testimony. Any witness wishing to give testimony on a particular case shall notify the board of such interest. This shall be done by filling out a speaker's card. If you're here in attendance, come down to Rosalie, fill out one of these speaker's cards so that we can call on you at the appropriate time. Or if online, registering a desire to comment is noted on the published agenda. Also, at the appropriate time for each case, the chair will ask those attending in person and online who wish to speak to a case to raise their hand by clicking on that icon on the webinar screen. And I made a mistake. Actually speak to Rachel, who's helping somebody with it right now. She's raising her hand. Staff will provide the chair with the names of persons who have registered and noted a desire to comment, and those registered participants who have raised their hand. The chair will call on each named participant one at a time. Such testimony shall be limited to a maximum of 3 minutes. However, the actual amount of time allowed for testimony shall be at the discretion of the board chair. The chair will conduct the hybrid in-person and virtual public hearing according to the bylaws and according to the rules established by the chair regarding public comment. Votes will be done by roll call vote only, and the chair, me, will verbally identify the specific members responsible for all motions and seconds. Go to the minutes for June 20th, 2024. Any changes or additions from any of the board members? All right, those are considered approved. Move on to the regular agenda. Item number 1, BA 2024-014. Turn this over to staff. Darren?
Mr. Chairman, this is BA 2024-014. It's an appeal of a staff interpretation of the zoning ordinance in regard to wholesale nursery versus retail nurseries in rural zoning districts. I do not believe the appellant is here today, but I'm prepared to go forward. This case was continued from May 10th and May 16th and June 20th to the day at the request of the appellant. Specifically, there are questions. What does it mean to propagate plants? What does it mean to distribute plants produced on premises? And what does it mean for plants to be brought to the premises? Again, this interp is not site specific. It's a countywide application. It's an interpretation of the meaning of words or phrases as used in the ordinance. The current interpretations from staff with regard to Zoning Ordinance Article 501.2.11 is that wholesale plant nurseries are permitted by right in rural zoning districts. These nurseries propagate plants, meaning that they care for plants in the temporary home, growing them into larger plants until they're ready for transport or distribution to or by the retail nurseries, landscapers, and contractors who sell the plants to or install them for the end consumer. In regard to Article 1301.1.12, retail plant nurseries are permitted in rural zoning districts only with legislative approval of a special use permit. The plants are often, but not necessarily, grown and propagated elsewhere and are brought onto the retail premises. These retail nurseries are able to sell plants directly to the end consumer. The appellant interprets Article 501.1.11 as it applies to rural zoning districts, that it allows a property owner to have a small plant nursery in their backyard, 1 to 4.3 acres, to sell plants they produce on the premises and nothing else, as long as it's only for wholesale, They're not allowed to import plants onto the premises or have retail sales. And in regard to 1301.1.12, and I'll note there's a typo in the second page where I refer to Article 1301.2.12, but it's 1301.1.12. As it allows for the import of plants, trees into a nursery for sale, wholesale or retail, and requires an SUP. The import of plants, trees into a nursery no longer limits the size of the nursery because of the huge amount and variety of plants, trees that can be imported and stored in the same size lot that wouldn't have been able to produce on said premises. The main reason for requiring an SUP under this article is to prevent a large industrial nursery from coming into a single family residential farming neighborhood zoned rural 43 and without neighborhood participation or approval. So the staff recommendation in paragraph 14 is that the board uphold the current staff interpretations. Happy to try and answer any questions you may have.
Thank you, Darren. Great overview. Are there any questions by any of the board members of staff? See shaking heads, so no questions of staff. You said the applicant's not here, but it should.
I'm not aware.
Public hearing though, right?
I'm not aware if the applicant's here or online.
Okay. See Wayne nodding his head yes, and I thought so. I am opening a public hearing. Is there anyone in the audience who wishes to speak on this item? I have no speaker request cards. Nadia or David, is there anyone online? Nobody
I'm not
online?
aware of anyone online wishing to speak.
I'm sorry, David, I only caught part of that. There is someone? No.
No,
there's
I'm
no
not
one.
aware of anyone.
Okay, all right, I'll go ahead and close the public hearing and turn it over to the board for discussion and or a motion. Remember, this is not district specific or site specific, it's for the entire county. My only comment on this is I agree wholeheartedly with staff's interpretation of this. It's been a long-standing practice and don't see the need to change it today. That's me personally. Anybody else? Member Clapp.
Thank you. I move that we approve BA 2024014. I think the staff's interpretation is very clear and the proposed changes were not clear to me, so we should not be making any changes to this.
Mr.
Thank you.
Mr.
We have a motion by Member Clapp to uphold staff's interpretation
And not to approve the appeal, but to
and
deny
not
the
to
appeal and
approve the
uphold it.
appeal. That's what your intent, right? Commission or Board Member Clapp?
Yes, to uphold
Yes.
it.
All right, we have a motion to uphold staff's interpretation. Is there a second? Second by Member Ward. Rosalie, if you'd please take roll call vote.
Member Cardin,
Yes.
Member Ward,
Yes.
Member Clapp,
Yes.
Vice Chairperson,
Yes.
Chairman Loper.
Yes.
Chairman, we have a motion to uphold staff's interpretation by a vote of 5-0.
Thank you. Move on to agenda item number 2, BA 2024-012. Turn it over to staff. Mr. Johnson.
Thank you, Chairman and members of the board. Case BA 2024012 is for the Schnell property in Supervisor District 4. The site is located at 10002 West Andover Drive in the Sun City area, is zoned R16, and is approximately 8,325 square feet. The highlighted portions on the site plan shown illustrate the unpermitted additions. The patio cover to the south, east, west, and north encroach required yard setbacks measured from the property lines. The site plan also illustrates the required setbacks for the zoning district. The residence was built meeting the required setbacks per the subsequent rezoning and recordation of the subdivision plat for Sun City 1. The setbacks function as separation distances between habitable structures and property lines. Since the additions were unpermitted, there was no way to notify the owner that the additions would not meet the required setbacks. The unpermitted construction is substantial and was erected over a period of 4 years since 2020, as captured on county aerial photography shown, without benefit of issued permit clearances, and because these were erected without the benefit of permit and clearances. Because of this, there is no warrant for the variance. The table shown illustrates the standards for the underlying zoning district with those requested by the applicant. Minimum front yard setback, building to the south property line, 6 feet 2 inches where 20 feet is required. A minimum rear yard setback of 10 feet where 25 feet is required. A minimum side yard setback of 0 feet where 5 feet is required. And overall lot coverage of 65% where 50% is the limit, is the maximum allowed. After reviewing the submission, no peculiar condition has since been identified by the applicant with this request. The site is relatively flat and void of unusual physical conditions that would prevent reasonable development of the parcel. In fact, the property is already developed with a single-family residence in compliance with minimum setback requirements, but the unpermitted additions do not comply. Staff cannot identify any requirement of the ordinance that, when applied to a peculiar condition, creates an unnecessary hardship preventing reasonable development of the property. In fact, the property is already developed with a single-family residence, thus a variance is not warranted. The applicant has failed to demonstrate that the general intent and purpose of the Maricopa County Zoning Ordinance will be preserved with the variance. The property has been developed and may be redeveloped in multiple ways without a need for a variance by modifying the existing additions. Therefore, variance approval would impede the purpose of the intent of the zoning ordinance that seeks to adequately separate habitable structures from property boundaries. If the board finds the applicant has satisfied the statutory test and has stated its findings on the record, the grant of this variance will memorialize the following. Variance approval establishes a minimum south front yard setback of 6 feet for APN 142-62514. Additionally, a variance approval establishes a minimum east side yard setback of 0 feet, minimum west side yard setback of 0 feet, maximum lot coverage of 65%, and a minimum north rear yard setback of 10 feet for APN 142-62514. At this time, I'll be happy to answer any questions. Thank you.
Thank you, Daniel. Great overview. If you could, I think there was an exhibit that identifies the structures in question, or maybe it was the comparison of the before and after aerial photos, this one. So they've got basically a driveway cover. They've got, looks like are these structures are all of these additions to the home, or are they standalone structures that are up against the home? So they're tied into the truss system.
Correct. These are additions to the single family residence. They are tied to the single.
They're not detached.
They are not detached.
Okay. All right. Thank you for that clarification. Any board members have any questions? Not seeing any at this time. Go ahead and open the public hearing. The applicant and property owner, I understand, are online. Nadia,
I have
David,
Amy. Yeah, I have Amy unmuted. She should be able to speak.
go ahead.
Thank you. I don't know if I'm on camera as well or just audio. I can only see the board members and the presentation. I do have a PowerPoint presentation. My name is Amy Wilson. I'm with the law firm of Gottlieb Law. For the record, the firm address is 2375 East Camelback Road, Suite 600 in Phoenix. And online as well as the applicant Ann Chanel. I appreciate being able to do virtual. I'm recovering from COVID, and so I did not want to appear in person and potentially infect everybody. So I appreciate the accommodation of being able to appear virtually. Can I control the PowerPoint presentation, or do I have to ask for advancement with someone in person?
I believe, and I believe it has to be controlled by here, and Rachel will handle that, correct? Or is that not?
Okay. All right.
Okay.
Okay.
All right. Yeah, just say
All
next slide.
All right. Thank you. Next slide. This was just the introduction here. Okay. So this is the overview of the location. The circle there is where the location of Ms. Chanel's home is. It's in for context, this is in Sun City. The house is in Sun City. In one of the older phases, the lots are a little bit smaller, and this is a larger house. This just shows the location of the house on the street. Next slide. If you can click one click, so I do have photos that are gonna, and then this is the variance request is just, you can stop right now. Leave that for right now. The variance is for all four of the structures. They were built over a period of 2 years. The last one, which is the one in the front for the car cover, I guess you might, for lack of a better word, carport, open carport, was built in 2021. The others were built in 2020, in 2020 as well. I detailed this in the application. So for the aerial view, notice the location of the structures, the uses, and I'll show a photo here and additional photos here as I advance. These are additions to the home, but they are not enclosed additions. They are basically metal shade structures that the three in the back are they are attached to the fascia. That was constructed by a contractor with materials that meet the building code. But you utilize these outdoor spaces as part of her living space. So this is shade, strictly for shade, and to be able to utilize the outdoor space. Without these shade structures, you would not be able to enjoy the outdoors in the shade. I want to mention, just for context, there was a recent news report, and a link is provided at the end of the presentation, about the city of Phoenix. I know this is the county island, so it's not city of Phoenix, but in general, the other cities, city of Phoenix in particular, is looking at shade initiatives to increase the availability of shade both in trees and in other structures for residents, because there's been a study showing that certain areas of the city, especially in the Wiz Valley, and I think Sun City, it would be one of those areas, even though it's not within City of Phoenix proper, that has a low percentage of shade availability, like 5 to 10%. And Sin City may be in the 5% range, because I know a lot of the area is desert landscaping, with some houses have shade, but not very many. All four, and the benefits of the shade. The study was, the report was citing studies were discussing the benefits of having shade. Decreases the load, heat load on a human body by as much as 10 to 20 degrees or more, just being in the shade, having the availability of the shade. We understand that yes, these were constructed without permits, without the variance. At the time they were constructed, Mishna was relying on the advice of the contractor who was building them, led her to believe that she did not need any variances. She knows that there are certain things that do need permits. There was an electrical improvement that she got a permit for, because the contractor said, hey, we need a permit for this item. So it's the contractor if she was aware that she had needed a permit, variances for these structures, she would have gone through that process. Now that she's aware that that is required, that's why we're trying to remedy this now, because it was brought to our attention that these structures did not meet county requirements for variances, and also requiring permits. For this process to approve, we are going to move on to the next step and go through the permitting process. And she's already consulted an engineer to be able to do that process. So if I can advance, yep, the other photos here, 3 more clicks. These are views of the usage of her space in the front. It is a cover that covers her car, as well as a seating area out front, so she can use the back aside. There we go. Stay right there for a minute. This one shows the side awning. There, she uses that as well. This is a photo of looking under the shade structure in the back here. and this is the one on the east side. Again, she uses all these spaces, outdoor spaces, as part of her living. If she didn't have the variances, she would not be able to utilize these spaces at all. She has tried to use umbrellas and other sorts of covers that are ineffective. They get blown away, they deteriorate, and she's tried other methods, but this was the best solution for her to be able to utilize her outdoor space. If you can advance to the next slide, please. So this is example. This is the site plan that Mr. Johnson was talking about. If you can do 2 clicks to show the bullet points. So the lot size, even though that there aren't unusual conditions of the site physically, it's the size of the lot with the size of the house that create the condition where it requires a variance even to build the structures. If without the variances for any of the structures, you probably can see this better than I can on the screen, but the setback of 25 feet in the backyard, she would not be able to have any shade structure at all in the backyard. You should be resorted to use umbrellas and things like which are ineffective. So there'd be zero ability to have any shade structure in the back. And then on the sides, it would be like 4 or 5, maybe 7 feet. Again, not really able to utilize the same on both sides. And on the front, with the setback being 20 feet, it brings it to the front line of the house. So again, there would be no availability to have shade. So even though physically the site conditions are such that there isn't an unusual site condition physically, but with the size of the house on the size of the lot, not having the variances under the test 1 and 2, this would create it's an unusual site condition from that perspective, and it creates an unnecessary hardship with those setbacks because of the size of the house. Again, shade is essential in Arizona to be able to utilize the outdoor space. If you can go to the next slide, please. Again, this is another area of the street. If you can compare the size of her house with some of the other houses on the street, some of the other houses are slightly smaller, so they are able to have shade structures either attached. It's hard to tell from this view whether or not they're attached or detached. They're able to have structures, while still probably either meeting variances or having gotten those variances. But because of the size of her house, of Ms. Snell's house on that lot, that none of these shade structures would be possible without any variances. Next slide, please. And then this is the table that Mr. Johnson was discussing. So yes, we were requesting the variances from 20 to 6 in the front, 10 feet in the back, and 0 on the side for the already constructed lot. I will note, can you 1 click, please, to bring up the percentage there. I know in the site plan, that the draft person that drafted it calculated the coverage, the lot coverage as 65%, because there was the way the lot coverage is defined, it's supposed to include the first 2 feet of the overhang. Because the site plan says 65%, we're going to go ahead and ask for that variance for at 65% because that's what's on the site plan. We may not be able to amend that before we go forward with permitting if we get to that stage. But I just want to make note that per the definition of lot coverage, the first 2 feet are excluded. So technically it is a 58% lot coverage as opposed to 65%. But for the purpose of the application, we're noting that it is 65%. And next slide. Yeah, you can go ahead and add all the bullets. It's fine. I can talk about them. So that's the link. Oh, back back to the prior one. Sorry. Thank you. So yeah, that was the link to the news clip I was mentioned earlier. That citing the study is about the need for shade and how City of Phoenix and other municipalities are looking at implementing shade initiatives to increase the percentage of shades in areas that have extremely low percentage. And I think even though this is a county area, I think the Sin City would fall in that grouping because of the amount of desert landscaping. So it's probably in the 5% coverage. Again, the majority of lots have desert landscaping. There was no shade structures when Ms. Schnell purchased the house in 2019. And she does utilize her outdoor space in order. She needs that shade in order to make effective use of the outdoor space. And then the shade structures are not possible without the variances. And again, if we had kind of from the beginning, if she had known there were permits and variances required from the beginning, we could have done this to begin with and moved through this process. Again, we're trying to remedy that with this. And then the construction of all these shade structures, according to the engineer we've consulted, does meet the building code and the fire code, so that will not be it won't be an issue for the permitting. And neighbors, and I know there are two, the HOA and one other that I think lodging objections today, but other neighbors do support. The neighbor directly to the west has lodged support. He's the homeowner. He doesn't have any objections to the strigs, and as well as two others down the street. Other neighbors have had to make amendments to their shade to meet the HOA variance or HOA requirements, and some of them have been altered to the point where not necessarily as usable. And that is something we can address with the HOA as how to how to address their concerns. I know when we've discussed with the HOA their objections to the front shade structure, I want to note that from what I understand, unless the HOA has changed their position, that up to this point the HOA has only had objections to the front shade structure over the driveway. They've made no objections to us, anyways, regarding the other shade structures, and specifically the objection from the front is where the location of the poles, because those poles are on the property line. They want them moved outside, either outside of the setback. They're 3 feet or 5 feet. They want those moved, and again, that changes the usability of that shade structure because you can no longer park in that spot. But that is something we can address with the HOA if the board approves this variance. So we know that whether or not the HOA has denied her Ms. Schnell's variance application previously through the HOA. There's two different layers of government oversight on this, and I know the HOA is going to ask you to deny, but at the same time, they have not expressed any objections to the other variances, and also if it's approved from the county's perspective, at the next stage we can address the HOA's concerns and figure out what we need to do to either bring it into compliance or make other arrangements on this. But we want to exhaust all avenues of the county requirements first before we make any concessions on the front carport. And you can next slide. Thank you for your time. I appreciate having the opportunity to present today. I'm open to any questions. And Ms. Snelly is here to answer any questions that I may not be able to answer.
Thank you, Ms. Wilson. Member Cardin has a question. Go ahead.
Thank you. Does approval here override the HOA such that the HOA would have to say, okay, well, now you're in compliance, and so we can no longer enforce the violations on the HOAs from the HOA's perspective?
I appreciate that quite.
Go ahead. Sorry. Go ahead, Ms.
No,
Wilson.
go ahead. If you have something to say.
No, he was asking that of you, not of me. My apologies.
Oh, okay. I know the HOA and we disagree on that. There is case law that would the HOA said that they wouldn't override, but there have been situations depending on who's on the board of the HOA that they have stated that they would defer to the county. So that is just something I think we're going to have to. I don't know if it would. Our position that it would either, if not override, would strongly encourage the HOA to amend their position on the variance, but at the same time, if that is something we will have to address with the HOA.
Thank you.
Thank you. Any other board members have any questions of the applicant? Darren, did you want to opine on the question or?
Sure, Mr. Chairman. Yes, the county zoning and private deed restrictions covenants, two totally separate tracks. County's not party to the HOA rules, deed restrictions, CC&Rs. Do not take them into consideration. We only enforce and consider the zoning. So the HOA rules and the private covenants are really irrelevant to anything we're discussing today. They can enforce separately regardless of any action we take.
All right, thank you. Any other board member have any questions of the applicant? I have a couple. You mentioned that you're not aware, or you have the neighbor support. Do you have and we have some speaker request cards, so I don't know if these are the same neighbors, but the ones to the sides of you, have you spoken with them? Do you have anything indicating they're feeling one way or another, that they're in support, not in support? Do you have anything written to that effect?
Yes, in the staff report, there are 3 letters of support. One of them, the text message screenshot from Denny Nichols, is the neighbor to the owner of the property to the neighbor of the neighbor to the west. I believe he has a renter there. But Danny Nichols, as the owner of property to the west, does not have any objections. The other James Reagan was the former owner of the property to the east. He no longer lives there. To my knowledge, unless the person who was there in person is a neighbor to the east, there's not the neighbor to the east has not objected, to my knowledge.
All right, thank you. And my other question is, you mentioned you received electric permits for these structures. Was that for lighting, ceiling fans? Do you know? And I'm also asking a question of staff. Are you aware of any related permits that would have extended to possibly include a site plan that showed the structure at the time of submittal?
Staff was
Oh,
able
I
to
can clarify. To clarify, what I intended, what I meant was that the permit noted in the staff report was something unrelated to the structures, from what I understand. It's for other electric. Is a 200 amp load center with breaker. So this, I mentioned in the context that when she knew that there was a permit required for something, she did obtain it because the contractor said informed her she needed a permit. And that's why there was a permit obtained for that. That was unrelated to the structures.
All right, thank you. And I see Daniel nodding his head yes. So, all right, I'm going to go on to other public for the applicant. Please hold tight. We may have other questions for you. Also online, I see that Ann Schnell, the property owner, wishes to speak or may want to speak. Daniel or Nadia, are you showing her?
Ann is online. I have her unmuted if she would like to speak. She may not.
Doesn't sound like she's indicating that she wants to. Before I go to the speakers that are here present, since we're already doing online, is there anyone else online who wishes to speak on this item?
No one else online has indicated a desire to speak.
All right, thank you. Then I'll go to those that have submitted speaker request cards in no particular order. Rick Gray, who says that wishes to speak and he's opposed to this request. If you could provide your name for the record, please.
Yes, thank you, Mr. Chairman. Rick Gray. I am actually, for full disclosure, an employee, a compliance officer with Sun City Homeowner Association. So I want to thank you for hearing this and members for your willingness to serve on this committee. I just have a couple of things. One, you should have gotten a letter from our general manager. I don't know if you all have that and have read that. If you have, I won't go over it. If not, I would like to take a second to read it.
Feel free. I believe it was in the packet. I thought I'd seen it and read it. You could just summarize it. You don't need to read it verbatim.
Basically, she's asking you to deny Ms. Schnell's variance request. I won't go a lot into that. I will say, one, if Ms. Schnell had used licensed contractors, they would have had to have gotten a permit. If they didn't, then you have recourse with the Register of Contractors to go back on them, and they've got a fund that would help cover that cost. So if you're dealing with unlicensed contractors, I'm a former contractor, so for full disclosure, if you're dealing with unlicensed contractors, then you don't know what you're going to get, and this is what we end up with. I want to make a note on the Code Compliance Division. On their first page, it's marked that the respondent admits, which is Ms. Snell, that the property is at this time in violation of the zoning ordinance. So we know it's in violation. We know the county has certain restrictions that we have to follow in the construction trade, and they have been blatantly violated. At the end, she also signs on that she will bring this into compliance. So as I understand it, we either have to discard, give her the gratis to say, we're going to just throw out the requirements that everybody else in Maricopa County has to live by and let you be special, or we have to say you have to come into compliance. Just for clarity too, Ms. Schnell has not been cooperative with SHOA as we're trying to deal with this and address this. We did have, she did say we have to talk to her with her attorney. Her attorney actually sent us a letter, an email letter. One of the things that she says, and I'll read it to you, she says, and also the lack of clarity from the HOA board regarding what part of the parking canopy violates the CC&Rs has made it impossible for our client to comply with the HOA board's prior notices of violation. Well, that lack of clarity, I want to read you our section of the CC&Rs in number 5. It says the front line of any building erected upon any lot shall not be closer than 20 feet to the front property line. The side walls of any building shall not be closer than 5 feet to the side lot line, and not closer than 10 feet to the side lot if that lot line is adjacent to a street, so if it's a corner lot. Except that any garage or carport attached from the building may be erected on either side or back of the lot line if such garage or carport is located entirely within the rear half of said lot. And then the next point is the carport and storeroom attached to the walls of the dwelling may be placed not closer than 5 feet to an interior wall, lot line, and not closer than 10 feet to the lot line adjacent to the street. So to me, that's 8th grade level clarity. You've got definite points that you can measure off. And again, she did bring the case to us. She asked for a variance. Our board listened to it. We heard it, but we rejected it. Our mission for our homeowner association is to protect Sun City taxpayers through the fair and consistent application of the CC&Rs. That means for everybody. Just for a point of clarification too, a lot of times we think of HOA as 25, 50 homes, and you have to pay several $100s a month in fees. Sun City is unique. It's the original Sun City. It's unique in the fact that we've got 17,500 homes. 17,500 homes. Their membership is voluntary. You don't have to pay a membership due. If you do decide to pay to support what we're doing to maintain our property values, it's $25 a year. And so we're not trying to be abusive. We have our responsibility. Again, we are tasked to enforce these CC&Rs. And I would hope that you as a board would not only appreciate that, but also that you would do the same thing and enforce the Maricopa County regulations that everybody else in the county has to live by. And again, as a former contractor, my code book was as thick as some law books. We had to follow that, and it should be obvious that if you start making exceptions, and that's one of the things about the laws, if you start making exceptions, you set precedents. And if we set a precedence here because we just want more shade, well, then if anybody wants more shade, then they should be able to just ignore the county code. And so my encouragement, and I don't want to take too much more of your time, my encouragement, yeah, I see you're being gracious, but my encouragement is this has to be denied. I know from our point, and I appreciate the clarification that your decision isn't going to affect our decision. When you move into a city, into a community like this, when you got CC&Rs, when you buy that house, so when Ms. Cheryl bought that house, she had to sign that she read the covenants and restrictions. And again, that's CC&Rs, conditions, covenants, restrictions. There are certain restrictions. And we signed to say, and I'm a Sun City resident, we signed to say we agree to that. That's a contractual agreement. It's not a matter of just, I had agreed to that, but I changed my mind. You agree, so with all of those 17,500 homes, you're signing an agreement as a contract to say we agree to this. And so again, as a show office, we will continue to press. We might not have addressed the side issues yet, but we have on other houses to enforce that. We will enforce our CC&Rs. I hope you enforce your Maricopa County regulations.
Thank you very much. I do have one question for you. It was represented by the applicant that the HOA is primarily opposed to the front cover, but you mentioned that the side and rear, you may have some latitude. Or is your opposition for anything in violation of your CC&Rs?
Anything in violation, sir, Mr. Chairman, of our CC&Rs. Again, we might have addressed that originally. We've got another case. Interestingly, it's a case that Ms. Schnell reported on in another part of our Sun City. She reported them as being in violation before she even had a variance with us. We're still working with them to bring them into compliance. Okay. So we're not trying to be mean. We take time. We try and work with our residents. But you know, we may have begun to address this front, but yeah, we will obviously when we talk about fair and consistent, that means that the front and the sides have to be within the setbacks, which is again the setbacks that the county requires too.
Understood. All right. Thank you very much. Appreciate it. Appreciate what you do out there at Sun City. 17,500 homes is quite the task to keep track of. I have another speaker request card on this case from Kevin Hall, who says they are also opposed and wishes to speak. Mr. Hall, and I neglected to do this before. 2 minutes is the time limit. Obviously, I'll be gracious with that if you need to go over, but for not to be repetitive of the previous speaker, if you could, sake of time.
Thank you for your time. Not knowing what package you had, I brought and supplied some color pictures of the property that further expand on the discussion points of this. On both side covers, they are actually gated and or curtained off, as well as the side points to create additional living space. When we first bought the house, our house next door, I should clarify that, we are the neighbor that lives to the east next door to Ms. Schnell.
So if I'm facing the home, you're to the right?
Right, correct.
Okay, thank you.
We are here in opposition of this variance request because of we're expressing our opposition to this variance request. My name is Kevin Hall. In full disclosure, I was recently hired by SHO as a compliance officer before this or after this first started, but I'm here as a concerned resident of Sun City. The extension of the roofing materials on both sides has allowed additional living space for use with installing furniture, carpets, in some cases, lighting. It's not just a place where it's a situation of getting out of the sun into the shade. It's an actual living space. Our concern is a fire situation where electrical could be sparked and the furniture go up in smoke. The roofing structures on both sides are at the property line. So when it rains, the water does pool on our side of the property. When that occurs, there are two doors into the garage. The doors swell because of the pooling water. We are given tremendous latitude in our CC&Rs here, but this is excessive and most importantly, affects the safety of residents and our neighbors. We have lived in other HOA controlled properties, and this is without a doubt the most generous we have seen. We feel that there is ample room for self-expression without violating the safety setbacks of the front and side yards. Anyone choosing to buy in Sun City could have an opportunity to buy outside if they wanted to expand their property, but she has in fact signed off when she bought the property that she would be in agreement with the CC&Rs. That needs to be taken into exception. But the community has collectively determined that there should be a certain decorum, and I feel it must be adhered to. Thank you for your time.
Thank you. Are there any questions from any board members for this speaker or the previous one I meant to ask? And then just for the board members' reference, the last speaker presented a number of photos of the front and side yard areas of the building. I'll give these to staff to include in the case file. If any of the board members want to see those at a future time, there are, I messed up the order, but there are, I believe, 8 of them. Very good photos. Thank you. Is there anyone else in the audience who wishes to speak on this item? Are there any questions of the board members back to the applicant? Or does the applicant wish to have any kind of rebuttal? If so, you have 2 minutes.
Thank you. Yes. I want to respond to the comments from both Mr. Gray and Mr. Hall. I appreciate what I understand where they're coming from on this, but they have turned this into an HOA board meeting rather than a county board meeting. And so up to this point, that they're now, the board has, Mr. Gray is like, oh, now they'll look into these other issues. I think it's, they're looking, if we could address that with them. But specifically, Mr. Hall, the house was like this with the covers when he purchased it last year. They were already existing, and Ms. Schnell does have gutters on those covers, and he's never once mentioned to her that there's water entering his yard and causing problems to his property next door. She was not aware it was an issue because he does have gutters on those covers on the sides to be able to catch the rain and try and keep rain from going into our neighbor's yard. So we're not really sure why this is being brought up now in this hearing as opposed to have been mentioned previously. So I mean, it's just, and you said he is now the next door neighbor. We were unaware that he was opposed to this. This is the first time that we're notified of his opposition to this. And he's also seems to be representing even though he's expressed a concern to him, he seems to be on the side of the board as well. Again, they're turning this into a board issue as opposed to the county variance. And the variance process is there for a reason. Yes, there are the setback requirements, there are the code requirements, but if there weren't circumstances to allow for variances, there wouldn't be this process. So the position that if we start allowing people start allowing for variances, we shouldn't be doing that because then everyone would be asking for variances. That kind of defeats the purpose of a variance application process. So that's all I have on that. Are there any other questions?
All right. Thank you. Any other questions of the applicant by any board members? All right, thank you again. I'll go ahead and close the public hearing. And I do have a couple of questions of staff that I want to ask before we get into any board discussion. Lot coverage aside, the side and rear variance requests, if those were detached buildings, what would generally be the requirement for setbacks? Don't worry about lot coverage, but just setbacks.
Sure. So if Chairman, so if the structures were detached from the home at any length, they could be as close as 5 feet from the eastern, northern, and western property lines, up to 3 feet with a fire rating for those structures that encroach further than 5 feet to the property lines. The front yard never allows for structures.
Thank you. So,
Mr. Chairman, just to
go
add,
right ahead, Derek.
just to add, from the zoning perspective, if they're structurally detached and not under the same eave or roof overhang or under the same roof, they can be as close as 3 feet, barring construction safety building codes, which make it further. But it must be structurally detached, not under the same eave, and it cannot occupy more than 30% of the required rear or side yard. So there's a maximum yard coverage in addition to lot coverage, which would likely be exceeded. But the front yard cannot have any structures encroaching.
Okay, thank you. And just a general comment has been stated, but I want to clarify. We only look at the zoning development standards for a given property, and we get dozens of variance requests a year throughout Maricopa County. Some of those have their own CC&Rs, such as this one, or different deed restrictions on them. We can't look at those as part of our deliberation. It's knowledge for us, but it's not, we don't enforce those CC&Rs, just like in this particular instance, SCHOA doesn't enforce county stuff, county development standards. So it is its own decision-making body. It doesn't necessarily set precedents. A lot of people try to argue that it does when they come in for a variance. Well, they got it down the street, or we try to look at each one individually. And I think that's it for, I'm just going to add this for my comments. This is me personally. This is in District 4, but I don't have an issue with the lot coverage. The reason is that, as we just heard, the county would accept detached side yard and rear yard structures. And by detached, that can be a very minor amount. It just can't structurally be attached or attached in any way to the principal structure, in this case, the home. Darren, Daniel, jump in if I misstate something. But it does have a setback of a minimum of 3 feet, preferably 5 for those side and rear yards. There's some lot coverage, rear yard coverage requirements that may or may not need a variance. I don't have an issue with the lot coverage. I don't particularly have an issue with the rear patio cover. I don't support the front cover that's visible from the street. It's definitely out of character. There's not an allowance for it as a detached structure. And then with the side yard structures, the reason there's a setback, even if it's detached, is for the very issue that Mr. Hall brought up about drainage and having some separation. This is a single family detached neighborhood. It's how it was envisioned, how it was constructed. If theirs goes up to the property line, if Mr. Hall did the same, pretty soon it's an attached neighborhood or attached residential neighborhood, that's certainly out of character. So again, I'm personally not opposed to the lot coverage, although that may not settle issues with the patio itself. And I'm not opposed to the rear yard variance, but I'm not supportive of the front or side yard variances. With that, I'll turn it over to the board for discussion and or a motion. Member Cardin.
Chairman Loper, thank you. You know that 99% of the time I'm right in alignment with you. And frankly, I think I even am here. You know, if this came in just as a rear yard setback, which, by the way, according to the little thing I'm looking at, maybe I need to clarify this. It doesn't appear that they're asking for a rear yard setback variance.
Member Cardin, I apologize. There was a handout, and Daniel may have gone through this. There was a late addition, a clarification. They need, they're requesting a setback of 10 feet where 25 is required.
Okay, thank you for that clarification. I missed that. Regardless, I'll say this. Doing as staff recommended, which is to disregard the HOA issues, and I think that's worth focusing on. It really feels like on this one, and that I don't want to be too extreme here, but there's a blatant disregard for trying to, it's like grabbing as much as they can, and approving this feels like it would be rewarding negligent at least, and maybe even bad behavior. And generally I'm looking for a way to try and accommodate member or owner requests. I mean, that's pretty solid history, but this one just feels far overreaching to me. So and I don't know that we call out one. I don't even know if we can, but my gut's telling me just to deny the whole request.
Member Cardin, is that in the form of a motion?
Well, it's in direct opposite. Well, I don't know if it's direct. It's not in accordance with you. So maybe we ought to hear from someone else before I make a motion, but I'd be willing to.
I was just stating my own personal feeling. I agree with a number of things you said. And I feel bad for persons that don't use licensed contractors. Because we hear it all the time. People go door to door selling services that they shouldn't be and lead people astray. And I feel bad for Ms. Schnell because that sounds like that was very much the case. But I will go ahead. Are there any other board members who wish to make a comment and or make a motion? Member Person, Vice Chair Person.
Hi there. Sorry if I have my video off because I am having some technical difficulties and I have COVID, so I keep sneezing. But I agree completely with Member Cardin. I think that we don't have a peculiar condition here, and there have been, I don't appreciate the way that this was handled with the HOA, and think it could have been done differently. So I'm not inclined to support.
Thank you. Any other board members have any comments? Member Cardin, do you have another comment?
I jumped the gun, but I was going to make a motion.
Feel free.
I move that we deny BA 2024-012.
We have a motion for denial of BA 2024-012 by Member Cardin. Member Clapp.
I second that motion.
We have a second by Member Clapp. Rosalie, if you'd please take roll call.
Member Cardin,
Yes.
Member Ward,
Yes.
Member Clapp,
Yes.
Vice Chairperson,
Yes.
Chairman Loper.
Yes.
Chairman, we have a motion for a denial by a vote of 5-0.
Thank you very much. To the applicant, you've heard the board's decision. Please work with staff to bring this into compliance at the earliest convenience and with the HOA. All right, move on to the next item, item number 3, BA 2024-021, the Ford variance in District 1.
Yes, Mr. Chairman, board members, this is a variance to the rear west setback requesting 35 feet where 40 is the minimum permitted for a approximate half acre property plus at 20359 East Marsh Road in the Chandler Heights area. The subject site's flat and unremarkable except some unorthodox morphology. The resulting shape is due to a flood control project. This unique shape and associated easements are what lead the application for setback adjustment. The parcel is 28,917 square feet, which is determined to be LNC due to government action. This results in a building envelope of 10,800 square feet. Variance approval would result in a larger envelope of 11,248 square feet, an increase of 448 square feet. Based upon what the applicant submitted, staff has offered that the unorthodox morphology of the lot and its substandard lot area and width may be considered a peculiar condition. The peculiar condition was not self-created in the line of title. However, staff cannot identify any application of the ordinance that has created an unnecessary hardship preventing reasonable development of the property. However, should you make a finding for approval, in paragraph 14, staff offers items A, B, and C to memorialize the variance.
Thank you. Are there any questions of staff, Darren, at this time by any board members? Member Cardin.
Thank you. Just curious, do we know the size of the home that's being proposed and how that relates to the other homes in the area, the size of the homes in the area?
Mr. Chairman and Member Cardin, I need to defer to the applicant. I do not know if a home
Okay.
is
Thank
under
you.
construction.
All right. Any other questions of Darren or other staff at this time? All right, seeing none, I'm going to go ahead and open the public hearing. Is the applicant or applicant representative in attendance?
Yes.
Lance Ford?
Yes, that is
Okay,
me.
cool. Go ahead, just name for the record and then go ahead with your presentation and your request.
Yeah. My name is Lance Ford. My wife and I recently purchased this lot from Maricopa County through auction. We have designed the house plans. The house plan, or the question that was brought up by the member, the home is 2,825 square feet. How that compares with adjacent homes, I'm not too sure on how the size compares. I would say that the adjacent homes might range in 1,200 to maybe 1,500 to maybe 2,000 square feet in that range. The reason for our request for the variance is our home that we have fully designed, and we worked in coordination with Andrew through this process, and he's been super helpful and a great resource. We designed these house plans facing Riggs Road, and we were under the assumption that as our backyard setback would be that south side, but based on how the lot was cut up for the use of the Maricopa Flood District and the staging of materials, that and how the code then read was that west side of the lot ends up being the back setback, the backyard. So the variance requested is something of 5 feet. And as we can see, the west side of the home should create a pretty good barrier of noise, not encroaching to the extent of nothing more than to accommodate the home. Is there any questions in reference to the variance or the project itself?
Member Cardin, you have a question of the applicant?
Yes, thank you. So just to confirm what you just said, if the west side was the side yard, that's 35 feet away from the yard where it would have been only needed 30 feet. Is that?
That is, yeah, that's my perspective of it as well.
Okay, thank you.
Thank you. Any other board members have any other comments for the applicant? My only comment is I'm eyeballing through the aerial. I think the other homes are at least the size of yours and probably bigger. And maybe it's difficult to tell, but yeah, I think the genesis for the question was, were you forced to do a smaller home than you otherwise would have wanted because of the weird shape and orientation of the lot? Hopefully, Mr. Cardin, that was, you're thinking like I was for that. All right, well, thank you. Hold tight. We may have other questions for you. Is there anyone else who wishes to speak on this item that's in attendance? Seeing none, is there anyone online, Nadia or David?
We're not aware of anyone online.
Okay, I do have an email from a Lindsay Keller. She says that she's to the west, so this would be your neighbor, I believe, to your west. If I'm looking at this correctly. Says they're opposed to this. 1 acre per dwelling ensures a space for my family and our livestock animals. The lot in question is only 2/3 of an acre, but that's not, our variance is not debating the lot size. It's the setback based on the orientation. She mentions about the Sonoqui Wash Channelization Project, the access road causes runoff. She's questioning maybe some of the drainage in the area. Darren, as far as you know, flood control and drainage reviews looked at this and they don't have any issues at this time?
Mr. Chairman, that's correct. This was a flood control project.
Okay, it was actually a flood control project. She may not be aware of that, but I did want to, and actually it's a William Bisbing who wrote the email, came from a different person. So I did want to note that for the record. Seeing no one else, go ahead and close the public hearing. This is in District 1 and turn it over to the board members for discussion and or a motion. Member Cardin.
Chairman Loper, thank you. I read that letter of opposition and didn't, I thought they weren't necessarily addressing the request here. So I also feel like this is an obvious reason that we even have these variance requests. This one seems to make perfect sense to me. So I move that we approve BA 2024021.
We have a motion for approval of BA 2024-021 by member Cardin. Do we have a second? We have a second by member Ward. Rosalie, if you please take roll call.
Member Cardin,
Yes.
Member Ward,
Yes.
Member Clapp,
Yes.
Vice Chairperson,
Yes.
Chairman Loper.
Yes.
Chairman, we have a motion for approval by a vote of 5-0.
Congratulations. Good luck with your new home. Move on to the next item on the agenda, item number 4, BA 2024-023, the Oaks property in District 1. Nick, go right ahead.
Thank you, Chairman Loper, members of the board. Case BA 2024-023 is a request to establish a lot width of 139 feet on the Oaks property, where 145 feet is the minimum required in the Rural 43 zoning district. The owners are proposing to build a single-family residence on what is currently a vacant lot. The parcel was created following a series of recent lot splits. Though it meets the lot area regulation of the zoning district, it's 1 acre in size, it no longer meets the lot width regulation because the shortest lot line with street frontage has been reduced to 139 feet or 6 feet below the minimum required. It should be noted that the property is a corner lot, whereas the north lot line fronts Santan Boulevard. The west lot line forms the center line of the easement for 206th Street. Currently, the north is considered the front and the west is considered the street side. However, if the owners were to record a vehicular non-access easement along the north lot line, this would negate the street frontage along Santan. The west would then become the de jure front lot line by virtue of being the only remaining lot line with legal street frontage. And as such, the west lot line would then define the lot's width, which would increase to 315.5 feet. This would resolve the substandard lot width and would negate the need for variance. Currently, the lot requires setbacks of 40 feet from the north and south, 30 feet from the east, and 20 feet from the west. This gives the lot's building envelope a depth of 233.5 feet and a width of 74 feet. Alternatively, recording a VNAE along the north lot line would establish 40-foot setbacks from the east and west, as well as 30-foot setbacks from the north and south. This would reduce the building envelope to a depth of 44 feet, but the lot could still be developed. Per the site plan, the north-facing residence would measure 60 feet east to west by 40 feet north to south, excluding patio structures. If the residence were to be reoriented to face the west, and if the porch structures were to be removed, the residence could still fit within the reoriented buildable area. This way, the property could be developed without need for variance and even without need to significantly redesign the residence. However, if the board finds that the applicant has satisfied the statutory test and has stated its findings on the record, the grant of this variance will memorialize the following. Item A, variance approval establishes a 139-foot lot width for APN 304-91048W. This time I'd be happy to answer any questions.
Thank you, Nick. Great presentation. Just to confirm or clarify your comment earlier, this variance is really necessitated by the orientation of the lot, what we're calling the front versus the side.
Chairman Loper, that is correct. As I was saying earlier, it was created as a result of an awkward lot split. It was originally part of a much larger, almost 10-acre parcel. The lot split resulted in the shortest lot line with street frontage, which is the north lot line facing Santan Boulevard, that has only a width of 139 feet. However, the way we define lot width in our ordinance is that lot width is defined by the length of the shortest lot line with street frontage with legal street access. So feasibly, if a VNAE were to be recorded along that north lot line, then the west, which does have street frontage as well, would automatically become the front. That would be set to define the lot width. And because that lot line is over 313 feet in length, that would become the new lot width, and there would be no further need for variance because lot width at this point is the only only regulation subject to nonconformance.
Just for clarification, that would create a squat lot where the lot would be very shallow. It may be a very odd building envelope. So they may come in for a variance regardless for front or rear setback. But it would be buildable in staff's opinion.
Okay, all right. Thank you very much. Any other board member have any questions of staff? Seeing none, I'll go ahead and open the public hearing. Is the applicant or applicant representative available? I do not have a speaker card for a person. Come on up if you could and hand that card to Rachel at the podium.
Well, Chairman, I do have Kim online. Go ahead.
Oh,
Kim.
okay.
You guys hear me okay?
Yeah, hang on a second. Ma'am, are you the applicant? Okay. Hold on just a second. Sorry about that, Rachel. And sorry about that. David, if you could go ahead and have the applicant introduce themselves. And my apologies, I misidentified the person in the audience.
Hi, everybody. My name is Kim Richens. I am with Silverstone Construction and working with the homeowners on building a property or building out this property. And like the what was said previously was perfectly said. The problem that we're having is if we do face the house west to east, we lose quite a bit, and it would be a very strange setup where we only have 44 feet, where if it was north to south, we have 74 feet in depth to work with. That is taking into account the easement on the west side, and it just makes a very long, skinny lot to work with. It's very difficult to design a decent home and to when you own an acre it's difficult to have a the home that you would like on this. And so we are asking for to adjust this. We're not asking for to reduce our setbacks. We're not asking to reduce the lot coverage. All we want to do is recognize the north as the front. And unfortunately, 6 feet is what is really making the difference here. If they would have split it with the 145 feet, we wouldn't be in this variance right now or requesting this variance right now, but we're at 139 feet. And it makes a difference. It makes a difference how he uses his lot and in his future plans for the lot. So we do humbly request that you grant us this. And again, we are not asking for a reduction in at this time, asking for a reduction in setbacks or lot coverage. Thank you very much.
Thank you. Are there any questions of the applicant from any of the board members? All right, seeing none, and since we're already online, David or Nadia, is there anyone online who wishes to speak on this item?
We're not aware of any other speakers.
All right, then I'll turn it back for those in attendance. I do have a speaker request card from Yolanda Rodriguez. If you could please come up to the podium, and I apologize for misidentifying you as the applicant previously.
Yes, sir. My apologies for not getting the speaker card in earlier.
No worries.
My name is Yolanda Rodriguez, and I grew up.
Could you make sure that you're the microphone as you're speaking into it?
Okay, I'm a little short, so I'll stretch a little here. My name is Yolanda Rodriguez. I have lived on the property very close to that particular lot all my life, and I will say I'm 57. Moved there when I was 53, so I'm very familiar with the splits that have occurred. And yes, that is an extremely awkward plot. They've made use of it so far, putting horses on it, which I think is a good use. This is the first that I'm hearing of this property design and the home property there. And mostly I'm here to gain some more information and to express the concern of the roadway that is between that property and the property that's shown in the photograph. There is a roadway there that is the only access to our property at 20529 East Santan. And because of the awkward splits from Mr. Orton, his original property back in the day in the 1960s, that has left us with flood zone difficulties with the roadway as the area around our property has been, built up around there. So I'm mostly here just to express concern over that roadway and how that's going to be used. I do know that there are people who are buying into that particular area that is causing some concerns with us as we're getting flooded out every monsoon. So it's not necessarily in opposition of, nor in support of that particular build. However, it is a request for more information on how that roadway will be utilized. And also the bottom part of that picture is cut out another wider aspect. It's almost an L-shaped plot that is not showing where it might also be another placement for a dwelling. But thank you so much to the board and the committee for hearing my concerns.
Thank you. Are there any questions of the speaker? And hold on a second, Ms. Rodriguez. I want to get back on that question. Anything else from any board member? All right. Is the applicant still online? Mr. Richens, were you able to hear the questions of your neighbor?
Okay, thank you. He had me muted there for a second. Yeah,
Okay.
so we are very aware of the roadway there, and as far as flooding, you're looking at our grading and drainage plan on the screen right now. That was designed, and we worked right alongside the people in Maricopa County, and in designing that and placing that. So this lot is is well designed for drainage right now, and I don't see any issues with that. We don't plan on having a lot of traffic down there except for the house that we look to building, so we would use it just as you use it. It is an easement for that purpose. I mean, that's why they take up some of the lot for both sides of the lot, or both sides of the property line for easements. And it is recorded, and that's what the easements are for. But as far as drainage, we are going to comply with what Maricopa County requires for our grading and drainage plan. And when that is approved, we will abide by that to make sure that we are not flooding out any of our neighbors.
Ms. Rodriguez, any other comments or questions?
Yes, I would also ask Mr. Richens if he is aware of the easement along Happy Valley or Happy Road that has been blocked off by your neighbors to the south by fencing. That is supposed to be an alternate easement to gain access, a secondary access to not only your property, but mine as well. And then just over the years, people put their own fences and it's been moved. That is another concern. I would request Mr. Richens, if it's possible, and if it's okay with the board, for me to give him my contact information so that we could have a better relationship moving forward and be more aware of, I let him know of some of the other areas that have the easement has been overran by our neighbors, causing these sorts of difficulties. I actually owned the properties that gave the easements up to the west. So it was my design to give up those easements for that access for my mom to continue.
Yeah, anytime I start a project, ma'am, I will go to the neighbors and hand you my card, because we're going to be good neighbors no matter what. And if there's ever any problem, we would like to work with you on that. Anytime I start a project, I'll come and talk to you personally. But yeah, I would love your contact information. We're glad to work. We've heard about the rumblings that are happening in the south that shouldn't be happening because there are recorded easements there. And you have the right, just like we have the right, to use that. So very familiar, or I've heard the rumblings about it, and it's unfortunate. We'll have to maybe partner up together and figure out how we can resolve that.
Yes, sir. I do believe that would be a good opportunity.
So to the applicant, the speaker request card has her email. If you want to, after the hearing, you could add your phone number. This becomes part of the record. And then Nick, if you could just get those exchanged between the two. I always encourage people to get to know your neighbors. And some of the issues may be off-site to this request, but it sounds like you guys are going to work together to try to resolve them anyway. Anything else, Ms. Rodriguez?
No, thank you. I do again express gratitude to the committee and the board for allowing me to speak today, and then Mr. Richens as well for addressing my concerns.
All right.
Thank you.
Thank you very much. Anybody else in the audience wish to speak on this? If not, I'm going to close the public hearing. Turn it back over to the board for discussion and or a motion. This is in District 1. Member Cardin.
Chairman Loper, here's another good example, just like the last case. I think this is, I appreciate the presentation and agree with the applicant. So I move that we approve BA 2024023.
We have a motion for approval by Member Cardin. Is there a second? We have a second from Member Clapp for BA 2024-023. Rosalie, if you please take roll call.
Member Cardin,
Yes.
Member Ward,
I think we just lost her.
Member Clapp,
Yes.
Vice Chairperson,
Yes.
Member Ward,
Yes.
Chairman Loper.
Yes.
Chairman, we have a motion for an approval by a vote of 5-0.
Congratulations to the applicant. Good luck with your project. Moving on to item number 5, BA 2024-024, the Kesty property in District 3. Nick, it's yours again.
Thank you, Chairman Loper. Case BA 2024-024 is a request for 2 variances on the Kesty property. Next slide, please. So this property is located in the Rural 43 zoning district, about 3,000 feet east of the northeast corner of 16th Street and Honda Bow Road in the New River area. The owners are requesting a variance to permit hillside disturbance of up to 1,550 square feet outside their lot's principal building envelope, where hillside disturbance is prohibited per the MCZO. The owners are proposing to build a single-family residence as well as retaining walls and a detached garage casita on what is currently a vacant lot. The owners are requesting an additional variance to permit a wellhead with a booster tank and an underground water storage tank within the street side yard setback, where the MCZO requires that no building or structure shall be placed outside of the lot's principal building envelope within any portion of a required yard that has a natural slope of 15% or greater. Here you can see an excerpt of the owner's site plan. Areas in green, about 15,200 square feet, are proposed hillside disturbance within the lot's buildable envelope, where such disturbance is permitted by the MCZO. Areas in yellow, about 3,300 square feet, are proposed hillside disturbance within the front setback, albeit related to the grading of the driveway, which is also allowed per the MCZO. Areas in orange, about 1,550 square feet, represent the remaining hillside disturbance proposed within the front and street side setbacks, the subject of the first variance request. And the area in red indicates the proposed wellhead, booster tank, and water storage tank, the subject of the second request. Next slide, please. So on one hand, a valid argument can be made that the need for hillside disturbance outside the building envelope could have been avoided had prior lot splitting not taken place. The subject site and two parcels to the west had been one combined parcel until 2021. Since this lot split, each of those western parcels had been developed with a residence. No variances are on file for either of those parcels, so had no lot split been recorded, development could have been feasible without variance. But on the other hand, the subject site meets all Rural 43 intensity of use regulations. No variances to the setbacks themselves have been requested. The residence and its accessory structures would be located entirely within the building envelope. Only the driveway, the retaining wall supporting it, and the water-related utilities would be located outside the building envelope. Furthermore, driveway-related disturbance is allowed by right to the extent that that only the minimum amount necessary is proposed, which appears to be the case here. The only disturbance proposed that would necessitate variance appears to be necessary to develop the property at all. Without such disturbance to stabilize the upper slopes within the setbacks, a reasonable development of the lot may not be possible. As such, the owners have made a compelling argument that applying the requirements of the MCZO would create an unnecessary hardship. The granting of the variances requested would allow the owners to enjoy productive use of their property. If the board finds the applicant has satisfied the statutory test and has stated its findings on the record, the grant of this variance will memorialize the following. Item A, variance approval establishes an allowance for 1,550 square feet of hillside disturbance not related to driveway or utility connection outside of the principal building envelope for APN 202-2442F. And item B, variance approval establishes an allowance for a wellhead, booster tank, and underground water storage tank to be located outside of the principal building envelope, but within an area of hillside slope for APN 202-2442F. At this time, I'd be happy to answer any questions.
Thank you, Nick. Great overview and presentation. Are there any questions of staff at this time? Seeing none, thank you again. I'll go ahead and open the public hearing. The applicant or representative in attendance who wish to come up and speak, do have a speaker request card from Tristan Kesty, and I'm guessing that's you because you checked the applicant box. If you could just provide your name for the record and go forward with your presentation.
Okay, thank you, board. Thank you, chair, and thanks, Nick, for the summary. My name is Tristan Kesty. I'm the owner of the property. I'm also designing the house. And just wanted to give you a brief bit of context about how we ended up here. And what happened was we have a couple of constraints that are pushing us in different directions, and they're in a little bit of a opposition to each other. And one of those main rules is keeping a separation from your septic to your well. And obviously, if we need to be able to pump the septic tank at any point in the future, it needs to be somewhat close to the driveway so that trucks can pump. And because of the hillside slope, there's a max distance we can go. They don't like to pump vertically. They don't mind pumping horizontally, but vertically is a bit difficult. So we've kept the septic tank as close as we can to the driveway and to the road, Honda Bow. And that 100-foot radius compels us to put the well and the secondary cistern tank somewhere to the north and, well, predominantly to the east, which we also want to keep near the road so that in the event that the well doesn't produce as we hope it might, that we can pump water and have water delivered to that cistern. So because of the separation of those two items and because of the setback, they are fighting against each other a little bit. So we tried to push the house up in elevation to minimize the uphill disturbance. We tried to push the house down to minimize the downhill disturbance. But what happened was the natural slope is about 40% across the property. And the geotechnical report says that we can really only do native stabilized slopes at 40 to 50%, depending on the soil that we discover. So we're a little bit hands tied. So the steepness of the lot is exceptional compared to the other two lots that are to the west. They only, in the buildable areas they're working with, were about 20 to 30%. So we're dealing with 30 to 40%, and that's quite a bit more difficult. And basically what it comes down to is, in order to keep the well separated from the septic, and in order to keep the cistern in a place where we can access it if we ever need to haul water, it needs to be near the road and ideally would be within the front side yard setback. So this is a street side setback, not the primary front yard setback, which, you know, makes maybe a little bit of a difference. But the cistern is going to be, or if this variance is granted, of course, it would be a buried cistern, and we would revegetate. And we have a booster pump, which is the standard small tank you see next to the wellhead to create pressure for the house. And one thing I've been talking about with my subcontractor is the possibility of moving that booster tank into the garage itself, so it doesn't, you can't see that from the road. So if we were to make that change, and if this variance were granted, we would ultimately revegetate and ideally wouldn't be able to see any of the disturbance. Now, obviously, this is the Sonoran Desert, so you're going to see some disturbance for some time. But part of what we're planning on doing in terms of mitigating the disturbance is we have rainwater harvesting tanks, and we intend to irrigate through the summer months to make sure the plants that are revegetating in the area we're disturbing, not just in the setback, but throughout the property, stay alive through the worst parts of the summer. And that at the end of all of this, if this was to be granted, you wouldn't be able to tell there was any disturbance in the side yard setback. So I think that sums up all of the things I wanted to bring to light.
Thank you very much. Yeah, definitely some constraints. I can tell those contour lines are very tight areas of this lot. Any questions of the applicant from any of the board members? All right, seeing none, hang tight. We may have some follow-up questions for you. As I mentioned, this is a public hearing. Is there anyone else in the audience who wishes to speak on this item? Seeing none, Nadia and David, is there anyone online? No.
There's no one online, Chairman.
No one online. All right, go ahead then. I'll close the public hearing and turn it over to the board for discussion and or a motion. This is in District 3.
I'll start out, Chairman Loper. I think this does represent a peculiar condition because of the topography of the site, and I'm prepared to make a motion to approve case BA 2024-024, subject to the language outlined in the staff report.
We have a motion for approval for BA 2024-024 by Vice Chair Person. Is there a second? Second by Member Cardin. Rosalie, if you could please do the roll call.
Member Cardin,
Yes.
Member Ward,
Yes.
Member Clapp,
Yes.
Vice Chairperson,
Yes.
Chairman Loper.
Yes.
Chairman, we have a motion for an approval by a vote of 5-0.
Congratulations. Best of luck with your new home. Move on to the next and final item. Oh, I do have an item after this. Just help me remember. Next item on the agenda, item number 6, BA 2024-025, the Hosking property in District 4. Nick?
Thank you, Chairman Loper. Case BA 2024-025 is a request to establish a rear yard setback of 9 feet on the Hosking property where 25 feet is the minimum required in the R16 SC zoning district. Next slide, please. So the property was created in 1960 as Lot 333 of the Sun City Unit 1 subdivision. The existing residence on site was developed that year. The property is a corner lot and both the front and street side lot lines are curved. The zoning district requires a front setback of 20 feet and a street side setback of 10 feet. The residence does encroach slightly on these setbacks. However, it must be noted that the residence was developed prior to the adoption of the zoning ordinance in 1969. Historical aerials show that no modifications have since been made to the residence to further encroach on either of these setbacks. And for these reasons, the residence is considered legally non-conforming with regard to the front and street side setback, so no variance is necessary for either of those. Next slide, please. That said, the residence features an attached patio cover that extends toward the rear lot line. Like the main residence, historical aerials show that this patio cover has existed since before the zoning ordinance was adopted. The zoning district requires a rear setback of 25 feet. And until 2021, the patio cover set the residence back from the rear lot line by about 20 feet. This too would have been considered an L&C setback. However, an unpermitted extension of the patio cover further toward the north lot line in 2021 negated the status. The residence, including the patio cover, is now set back from the rear lot line less than 10 feet. Next slide, please. So for an as-built construction permit to be issued, a variance must be approved to reduce the rear yard setback from 25 feet to 9 feet. If the variance is denied, the owner would be required to remove the patio cover extension back to whatever setback can be documented as L&C, or remove the patio cover until it meets the required 25-foot setback. Another option is to alter the patio cover so that it is structurally detached, but even then it would still need to meet max lot coverage and max rear yard coverage requirements. Beyond the rear setback, no further variances would be required to accommodate the existing development. With the information available, the residence appears to meet the required 5-foot interior side setback, and the lot coverage appears to be about 40%, whereas the max lot coverage allowed is 50%. If the board finds the applicant has satisfied the statutory test and has stated its findings on the record, the grant of this variance will memorialize the following. Item A, variance approval establishes a 9-foot north setback for APN 289-181. This time I'd be happy to answer any questions.
Thank you, Nick. Great presentation as always. Any questions of staff at this time by any of the board members? All right, seeing none, I'll go ahead and open the public hearing. Is the applicant or applicant representative available? Catherine Hosking? Could come up to the podium. Feel free to adjust the microphone and go ahead with your request.
Yes. 2 years ago, I built a garage. I enclosed a carport into a garage using a contractor, licensed contractor. He was to build the back patio. Restraints with his business. He was unable to be able to complete that. So the project got put off. Further down the line, he got busy and referred me to a colleague of his to build that patio. Unfortunately, I was under the assumption that his colleague was also a contracted licenser. He came, we discussed it, and being that 2 years ago I had built the garage, I knew a permit was needed. I spoke with him. I said, I know you work another job. If you need me to run down to the board and get the permit, I'll go get the permit. His thing was, oh, it's the backyard. I don't think you need a permit, but I'll check into all of that for you. Being that it was an $8,000 project, he knew there was not the 25-foot variance needed, the setback. He did not want to lose that job. He went ahead, built it. It's been built for 3 years. I have spoke with my neighbor to the left of me. He has no problem to what is in my backyard or the patio. The person behind me on 105th Street, he used to work for the zoning and planning board, and he said he didn't see that there should be a problem and that he has no problem with the patio cover being there either. It's barely visible over the fence. So I'm not sure how it got turned in, or I have a gut feeling, but out of vengeance, it was turned in. And it's just a simple 10 by 40 foot patio cover. The concrete slab was already there. It was under my impression that there had been a patio cover at one time, and maybe it deteriorated because there were posts there. I have spoke with the person who built it. He's being very nasty. So I assume the cost to put in for the variance. I have not encroached on the side yards like the other resident of Sun City. I tried to be very respectful of my neighbors. I just wanted a little shade in the backyard. I have fibromyalgia and have to be out of the sun to be able to enjoy my backyard. And I can only do that at certain times of the year with my illness. So I'm asking for the variance for myself, for my pleasure. I've had no complaints from any of my neighbors. They were totally appalled that anybody would have said anything, being that is in my backyard behind two cinder block walls that you wouldn't even know it was there if you didn't look over the wall. So, I mean, I'm asking for the variance so that I can enjoy my home and be able to get out at some times. And like I said, I try to work well with my neighbors, and they've had no complaints over this, so they're not sure how this whole thing started.
Thank you very much. Apologize that you had to go through some of those circumstances. Are there any questions by any of the board members of the applicant? Seeing none, if you could just hang tight, we may have some questions that come up. As mentioned, this is a public hearing. Is there anyone in the audience who wishes to speak on this? Rick Gray filled out a speaker request card. He was a speaker on a previous case saying that he was opposed to it, but I don't see him in the audience anymore.
Yeah, he asked to pull the card back and he wasn't going to speak after all.
Oh, okay. I'll leave the card for you, but all right. Anyone else in the audience who wishes to speak on this item? Do we have anybody, Nadia or David, online?
There's no one online wishing to speak.
Okay, I'll go ahead and close the public hearing. This is in District 4, my district. I'll just give my opinion on this. I don't have an issue with this. I do have a real quick question of staff, not to prejudice this particular case. So she mentioned that maybe at one time there had been a patio cover. If there were evidence of posts or anything, would that have kept, because the legal nonconforming only really goes away if more than 50%, I think, of the value or the whatever of the structure is lost. Would that have kept her that legal nonconformity status? Wayne's shaking his head no, so never mind. Anyway.
Mr. Chairman, you're speaking in regard to the legal nonconformity with regard to drainage and flood control regulations. Our ordinance actually requires any reconstruction or rebuilding or redevelopment to come into conformance.
Wrong ordinance I was referencing. Sorry about that. Okay, never mind. So I have no issue with the variance request, but I'll turn it over to the board for discussion and or a motion. Member Cardin.
Chairman Loper, I agree with you and the applicant. For the reasons stated by the applicant, I would move that we approve BA 2024-025.
We have a motion for approval by Member Cardin. Is there a second? We have a second by Member Clapp. Rosalie, if you please take roll call.
Member Cardin?
Yes.
Member Ward?
Yes.
Member Clapp?
Yes.
Vice Chairperson?
Yes.
Chairman Loper?
Yes.
Chairman, we have a motion for an approval by a vote of 5-0.
Congratulations and best of luck with everything going on forward.
I want to say thank you. This is been very trying for me. I've just tried to enjoy my property, and I just thank you all very much. And I will be speaking to Showa over this too. I've spoke with them this week, and I want to comply to all my residents and stuff. So thank you. I mean, like I said, I thought I hired a contractor who knew all the rules and regulations. So.
Sadly, it happens all too much, as we heard in the other
Yes,
cases as
I
well.
have.
So
Thank you
best of
so
luck.
much.
Best of luck to you. One final item on the agenda. Tomorrow is Darren's birthday. And there's no way that I'm singing to him on an open mic without a number of shots of tequila. No disrespect to Tom and to Craig, but Matt, I worked with you when long ago, I think it was last week when we both started. Probably. Do you have anything you'd like to say? Wow, that's quite the number. It's been enjoyable working with you and knowing you. So best of luck with whatever you do, which is hopefully a lot of fun things. Do you want to lead a happy birthday singing to Darren, or are we just going to leave it to a quiet individual well wishes?
That's probably better.
It is probably
Happy
better.
birthday.
Happy birthday
Hey to you. Happy- Thank you, everyone. We are adjourned.
Thank you. Happy birthday.
Thank you.